On March 15, 2023, law enforcement arrested Jose Chile de Castro, a prominent YouTube content creator recognized as a First Amendment auditor and anti-police abuse activist, on charges of obstructing and resisting a public officer. The arrest stemmed from an incident where Mr. de Castro approached and initiated a conversation with a motorist who was being detained by police during a standard traffic stop. Officer Brandon Bourque instructed Mr. de Castro to retreat to ensure scene safety, clarifying that he was fully permitted to record the interaction as long as he kept a safe distance. However, according to Officer Bourque, Mr. de Castro refused to comply with the order to step back. Following approximately a year of pretrial litigation and legal delays, the matter moved forward to a bench trial on March 19, 2024, in the Las Vegas Justice Court, Nevada, with Judge Ann Zimmerman presiding. After Officer Bourque completed his testimony during the prosecution's direct examination, defense attorney Michael Mee stepped up to begin his cross-examination of the officer.
Morning, sir. I'm well. How are you?
Very well. How many feet did you order the defendant to back up specifically?
I never had an opportunity to give him an exact distance.
How far back did you intend to have him back up, even if you didn't express that?
In the background of the video, you could see that there was a parked semi-truck and a light pole. I would have directed him somewhere in that area, which would have been outside the 21 feet.
Your testimony is you never told him an exact distance to back up, correct?
Yes, he never allowed me to.
What do you mean he never allowed you to?
I asked him to back up, and he continued arguing with me, so I can never specify exact distance for him.
But you had time to give him 5 commands to back up, is that correct?
Yes,
Your testimony is he never backed up when you were giving him commands, is that correct?
if he backed up, it may have been inches, but he didn't substantially back up.
And you just reviewed the body-worn camera from your chest, is that correct?
Yes,
Okay. You didn't notice him backing up every time you directed him to back up?
he did not back up.
So you backed up 0 feet, in your opinion? Based on that video?
Not 0 feet.
What was that?
He didn't back up 0 feet, he was moving his feet. As to exactly how far he went back, I don't know, but it wasn't substantial.
What would have been substantial in your opinion? Or what do you mean by that?
I would have guided him if he wasn't arguing with me back toward the light pole and the parked semi-truck.
And
Would have, again, would have been outside of the 21 feet. That was my goal.
So in your opinion, you have the ability, or you would in any traffic stop, ask somebody to move back 21 feet, is that correct?
Yes, for our training,
And what was that training?
that while we're conducting lawful activity, we're allowed a reasonable distance to conduct our activity.
But where do you get that 21 feet number from specifically?
That's taught to us in the academy. It's based on reaction time, normal human reaction time to a threat.
So your position is anytime you're engaged in any law enforcement activity, you would create a 21 feet perimeter?
Not necessarily, it depends on other environmental factors such as obstacles and barriers.
So your testimony is that every time you conduct a traffic stop, as long as there's no barriers, you would order a pedestrian to back up 21 feet, is that correct?
I would, yes.
During cross-examination, defense attorney Mr. Mee used the legal process of impeachment to challenge Officer Bourque's credibility under Nevada Revised Statute 50.135. He highlighted a major contradiction. The officer claimed Mr. de Castro was interfering, yet the evidence showed no physical blockage. While the state argued this behavior violated Nevada Revised Statute 197.190, the defense argued the footage proved otherwise. Mr. Mee pointed out that Mr. de Castro actually backed up to give the officer more space. He asserted that the officer's demand for 21 feet of distance was an unreasonable standard with no basis in Nevada law. Ultimately, by showing that the officer could easily perform his duties despite Mr. de Castro's presence, Mr. Mee sought to prove the arrest lacked a legal foundation.
Approximately how long were you issuing these commands to him before you decided to detain the defendant?
Approximately 15, 20 seconds.
And your testimony is you didn't have any time during the entire back and forth to tell him a specific distance to back up to?
Not time, but no opportunity.
How so?
Well, every time I tried to speak with him, he would argue he wasn't listening at all. So if he's not understanding back up, how he explained something that was more complex.
Well, what was preventing you from saying back up to a particular location?
First, I would want him to back up, and then if he didn't back up far enough, I would give him an exact location.
But you never did, correct?
No, I never did.
Did the defendant's verbal comments towards you influence what you decided to do that day?
No,
On the video, did you see that the point in time you decided to detain him was specifically after he made an insulting comment towards you?
that wasn't why I chose to detain him. I realized that he wasn't going to back up at that time.
His comments didn't make you angry at him?
No.
In your review of the video just now, he had both hands in front of him the entire time, is that correct?
No, at one point he reaches toward his back pocket to pull out his second phone.
Did you quickly see that it was a second phone he was going for?
Yes,
Okay. So once you see him produce the second phone in his hands, he's obviously not reaching for a weapon, is that correct?
at that time, no, he wasn't.
What time of day did this occur at?
If I remember correctly, I think it was around 4:30 in the afternoon.
And this was in a broad public place.
Yes,
Does the fact that this occurred in broad daylight in public influence your decision-making as far as issuing commands to the defendant?
it could. In this particular case, it didn't.
And why is that?
There was nobody around us other than me and the driver and DeCastro.
You testified he swatted your hand away, is that your testimony today?
Yes, that's the best way I can describe it.
And you saw his arm do this, or you just felt it?
I saw and felt it.
Do you recall in your police report stating that you did not believe his intent was to harm you?
Yes, I wrote that.
And what is your basis for reaching that conclusion?
Well, he could have been charged with battery on a police officer, which would have been more severe. But I didn't think his intent was to hurt me, so I didn't charge him with that.
You testified today that one of the things you were concerned about was him not going over to your vehicle, is that true?
Yes,
Will you agree with me that he actually did walk over to your vehicle at some point during the interaction?
yes, but it wasn't reasonable, the amount of time it took him.
What would be a reasonable amount of time?
Asking him to step in front of my car, then doing so immediately.
And how fast is it immediately?
This isn't based off of time, my response, it's just based off of interaction. I had to tell him he was detained multiple times. And I made it clear what he was detained for. I said he was detained for obstructing. And I gave him several commands to step in front of my car. So I would think a reasonable person would walk over to my car, and then we'd have a conversation there.
And how specifically did his presence obstruct your ability to complete the traffic stop?
Again, I don't know what his intention is. I don't know if he's armed. All I saw was him recording, which, again, I had no issue with. I told him I had no issue with. At some point in time, if I were to issue a citation to the driver, my focus would be on the driver and what's inside her car. At that point, I hadn't pulled her out. I hadn't pat her down. I don't know if she has any weapons in the car or what her intent was, if there was anything underlying. So my intention on having DeCastro back up was so that I didn't have split attention. He was too close for me to have split attention.
Mr. Mee questioned Officer Bork about his failure to provide a specific distance when ordering Mr. DeCastro to back up. Relying on the landmark legal precedents of Pennsylvania versus Mims and Maryland versus Wilson, Officer Bork countered that the presence of an unsearched passenger created a high-risk tactical environment. He argued this urgency required him to eliminate any external variables dangerously divided his focus. Mr. Mee also addressed Nevada Revised Statute 200.481, which defines battery as the willful and unlawful use of force against someone, noting that penalties escalate when committed against an on-duty peace officer. Under cross-examination, Officer Bork conceded that he did not believe Mr. DeCastro intended to cause physical injury, confirming the defendant was merely trying to grab a second cell phone. By establishing that the officer had already ruled out a weapon or hostile intent, Mr. Mee argued that the immediate escalation to a physical arrest lacked a genuine scene safety justification. Instead, the defense sought to show that the arrest was an act of retaliation sparked entirely by Mr. DeCastro's verbal pushback.
Were there other individuals around the traffic stop other than the defendant and the driver?
Not that I can remember.
Do you recall anyone walking through the scene and asking about the restaurant next door?
I don't remember that.
But your testimony is if there was someone else on the video, you would have been ordering that person to back up 21 feet?
I would have first asked them to back up, and most people do. And then if they did not comply, then I would give them a specific area to back up to.
You ordered him not to speak to the driver, is that correct?
Yes, well, I remember asking to back up. I don't remember if I specifically asked him not to speak to the driver. I think I may have said, don't talk to her, or something to that effect.
Did he speak to her before you got out of your patrol vehicle or afterwards?
Before. I saw DeCastro filming. I stayed in my vehicle and continued my business. Then when I saw him speaking to the driver, that's when I exited.
Did you see him speak to the driver after you exited the vehicle at any point?
I don't remember if he spoke to the driver after I exited.
At any point, did you hear specifically what he may have said to the driver?
No, I was too far away and it was windy.
Is your position that anytime you're engaged in a traffic stop, nobody can speak to the driver?
They can speak to them at a reasonable distance.
And is that 21 feet?
It could be shorter, it could be longer. Again, depends on the environment, totality, the circumstances.
Officer Bork clarified that he only intervened when Mr. DeCastro began speaking directly to the car driver. While the officer emphasized that he repeatedly ordered him to step back, Mr. DeCastro stood his ground, insisting he was fully within his rights to record the scene and converse with the driver. Under Nevada Revised Statute 171.123, it allows police to detain a person if circumstances reasonably suggest they have committed, are committing, or are about to commit an offense. Mr. DeCastro argued that because he was merely filming, the officer lacked the necessary, reasonable, articulable suspicion to demand his identification. Officer Bork countered this by asserting that the ongoing obstruction itself was the crime in progress, which legally authorized the demand for ID. On the same day, Judge Zimmerman found Mr. DeCastro guilty of obstruction and resisting, bypassing the prosecution's lenient recommendation to hand down a 180-day immediate jail sentence because she believed he staged the arrest for YouTube views. Mr. DeCastro's attorneys filed an appeal before the Clark County District Court in Nevada. On appeal, Judge Michelle Levitt overturned the conviction on July 10, 2024, ruling his conduct was protected by the First Amendment and releasing him after he served 100 days. On May 15, 2025, Mr. DeCastro launched a 42 U.S.C. civil rights lawsuit alleging false arrest and retaliation. As of February 2, 2026, the litigation is ongoing, with Clark County filing a motion to dismiss based on legal immunity and asserting that probable cause existed for the initial arrest. The next case occurred on August 21, 2022. Adams County Sheriff's deputies raided the Ohio home of rapper Joseph Foreman, known as Afro Man, executing a search warrant based on a confidential informant's allegations of drug trafficking and kidnapping. The operation left behind extensive property damage and a $400 shortage in the seized cash inventory. Mr. Foreman's subsequent lawsuit against the department was dismissed under Ohio Revised Code 2744.02, which shielded the sheriff's office with political subdivision immunity, protected individual deputies with qualified immunity, and legally deemed the property destruction an incidental consequence of a lawful search under the independent source doctrine. In response, Mr. Foreman exercised his First Amendment rights by utilizing his own security camera footage, publicly accused the officers of theft within his music videos. 7 of the deputies countered by filing a lawsuit against him for defamation and false light in the Adams County Court of Common Pleas, seeking nearly $4 million in damages. The trial commenced on March 16, 2026, where defense counsel David Osborne began his cross-examination of the plaintiff's first witness, former Deputy Brian Newland, who was in charge of executing the search warrant.
You were asked questions about a search warrant. Is it correct to say you were the chief in charge of executing that search warrant?
Correct.
Okay. And you counted all the money?
I did.
You had full control of it the whole time?
Not the entire time, no.
Okay. So, walk me through the process by which you cataloged the money.
So while we were conducting a search of the residence, another deputy located the money, I believe, in a jacket pocket from a suit.
Okay.
He handed me the money, explained to me where he found it. At that point, I start to count it in the same room. Once I count it, I collect it, put it in Evan's bag, and take it downstairs.
Okay. So, let's back up. That was very general. So when you counted it, where did you count it?
I counted it in the bedroom where it was located.
And you counted it on the floor?
Yes.
Okay. And you made specific piles?
Yes.
Okay. Now, that's not all the money that was recovered is what was coming out of the suit, right?
Correct.
Where was the other money recovered?
There was more money covered from, I believe it was an office downstairs
Okay. And where did you count that money at?
in that room.
On the floor?
I don't recall if it was on the floor or maybe on a desk that was there.
Okay, and you were wearing your body cam the whole time?
Yes.
What was the time difference between the suit jacket money and the money downstairs?
I don't recall.
You reviewed your body camera.
Yeah, it's been year. I reviewed it over a year ago. I don't recall what the time frame was.
Now, Mr. Newland, let's ask that question. You were deposed, correct?
Yes.
You were deposed on August 8th of 2025, correct?
Correct.
Have you watched the body cam since then?
I haven't. Well, I take that back. I've watched pieces of it. Haven't watched the entire thing.
What pieces have you watched?
Just of me of me counting the money from
So-
the bedroom.
You watched only the part of your body cam where you recounted the money in the bedroom only.
Correct.
You never watched the part for downstairs.
I did not.
You never watched the part where you sealed the evidence bag.
No.
Did you seal the evidence bag?
The evidence bag was not initially sealed. No.
What do you mean by initially sealed?
So it's not a self-sealing bag. It has to be taped. So it was placed in an evidence bag and then brought downstairs to a central location until it was transported to the sheriff's office.
In the central location, where was that?
In the kitchen?
And you left it there alone?
No.
Who did you leave it with?
When I first brought it downstairs, Officer Cooley was sitting at a counter and I asked him to keep an eye on it while I continued the search.
Okay, and did he keep an eye on it?
As far as I know, yes.
What do you mean as far as you know?
I mean, I wasn't there the entire time. I went on to continue searching the residence and come back down.
But wouldn't he be in the chain of custody?
Yeah.
So did he sign the evidence bag?
No, I didn't. He wasn't in charge of the custody in that sense of signing or sealing the evidence bag. I just brought the cash down while we was still conducting the search and asked for him to keep an eye on it.
So the cash was never left alone?
Not to my knowledge, no.
Were you interviewed by a Mr. Robinson in relation to this matter?
No.
Okay. Did you make a report about the missing money?
I didn't know.
So there was this question about a return on a search warrant. Can you explain what that is?
The return?
Yes.
It's just an itemized list of property that's seized from a location during a search warrant service.
Did it include an amount of money seized on it?
Yes.
Does that amount of money match what was written on the evidence bag?
Yes.
So as far as the court knows, there was more money taken than what was returned?
I'm sorry.
So as far as the court knows with the return, more money was taken than what was returned.
That's the way it appeared, yes.
Did you put in an amended search warrant return?
I don't believe so.
So you never corrected your statement to the court?
Correct.
Okay. Does the Adams County Sheriff's Office have a policy and procedure pertaining to the counting of money as evidence?
I believe so.
What do you mean you believe so?
I haven't worked there in almost 3 years.
Well, before you worked there, did they have one?
It was, I don't necessarily know that it was a written policy, but it was to have 2 people count the money.
Did 2 people count the money?
No.
During that time, when you started the Sheriff's Office in 2014, you reviewed the policies and procedures?
Yes.
So you would have seen the policy on counting cash.
If there was one at the time, yes. I don't recall.
So you don't know if there was a policy at the time?
Correct.
Okay. So how do you know it was supposed to be counted by 2 people?
That was the practice that we normally adhered to. It would be counted by one and then recounted by a second.
Okay. And the second person would initial the evidence bag?
No, it was just kind of like almost like a system of checks and balances. And then the seizing officer would still initial and seal up the evidence.
This may sound an extremely stupid question. How many times did you count the money?
I counted it one time.
Why only once?
At the time, there was so much going on, I counted the one time, put it in the bag, and until we got done.
Okay. So when you retrieved the bag, you never counted it again?
Correct.
Okay. Did you seal the evidence bag before you left?
I did not.
Did you seal the evidence bag at the Adams County Sheriff's Department?
Yes, it was sealed at the Adams County Sheriff's Office.
I didn't ask if it was sealed. I asked if you sealed it.
Yes, I would have sealed the bag.
Let me rephrase the question. Did the officers that you work with at Norwood put up a picture or an image of Mr. Foreman on your computer?
Yes.
Did you ask them to take it down?
No.
Did they think it was funny?
Yes.
And they're in law enforcement?
Yes.
Do they think any different of you because of this?
I don't know.
They don't treat you differently?
I work with them, but I don't really associate with them. I go there and I do my job and I come home.
When you interviewed for the Norwood Police Department, they never held anything Mr. Foreman said against you?
I don't believe so, no.
Okay. Would it be fair to say it did not affect your professional career then?
Oh, it absolutely did.
How so?
Even if I move locations from Adams County to Cincinnati or to Los Angeles, people still ask if I'm a pedophile. People still ask me what it's about. People still ask me if I'm a thief.
But the people you work with do not ask that, correct?
They don't ask me, I know.
When you were interviewed, your future employer never asked you that question.
No.
So then when you say it damaged your reputation, you're only referring to people in the public, correct?
No. That's just what people in the public is what I know. Maybe people do have bias against me, in law enforcement. I don't know.
Okay. Were you ever passed up for promotion because of this?
Not that I'm aware of.
Okay. Were you ever disciplined because of this?
No.
And you agree while you're out in the public, people are seeing you perform your law enforcement duties?
Yes.
And based upon what they see, they will make comments about you, correct?
Yes.
So how you perform your duties reflects on your reputation?
Yes.
As you've said that people can comment on your execution of your duties as a police officer, did you follow the procedure correctly in execution of the search warrant?
In the execution of the search warrant itself, yes.
Have you ever been accused before of stealing money from traffic stops?
Yes.
It was not Mr. Foreman that accused you, correct?
Correct.
Okay. Now you're claiming that by being called a thief, you were painted in a false light.
Yes.
And what exactly does that mean?
That I was being painted in a false light.
You've been accused of stealing from traffic stops before.
So being accused of stealing on traffic stops before was when money was seized and forfeited by the courts and no longer returned. And I was, quote unquote, called a thief. Okay. Never to this extent.
Okay.
Never to this broad,
But you would agree there is some similarity here. Money was seized here too.
Mr. Osborne targeted Mr. Newland's failure to implement dual control verification when handling the seized currency, forcing the former deputy to admit he counted the cash entirely alone. This processing method directly implicates Ohio Revised Code 2981.11, which legally mandates that law enforcement securely safeguard all seized property held as evidence. The defense contended that because the funds were under continuous supervision, a $400 discrepancy was procedurally implausible as a simple counting error. To establish a broader motive, Mr. Osborne introduced past citizen complaints accusing Mr. Newland of roadside theft. Under Ohio rule of evidence, prior acts cannot be used to prove character. They are fully admissible to establish a distinct pattern of behavior. The defense leveraged this rule to argue that the deputy routinely weaponized defamation lawsuits to silence legitimate misconduct allegations. The next plaintiff on the stand was Sergeant Randolph Lee Randy Walters. After Mr. Klingler finished his examination, defense attorney David Osborne started his cross-examination.
So you were called a couple names by Mr. Foreman, one of those being, what was it, Beetle Bailey.
Yes, sir.
Does anyone believe you're Beetle Bailey?
Probably not. That's a drawn cartoon.
Beetle Bailey is a cartoon that's in the newspaper.
Sure.
Been there for years. So that would be an exaggeration. And when they call you a son of a bitch, that would be an opinion.
I'd say that would be an opinion.
Because there's no way we can prove whether you're a son of a bitch or not.
Nah, she's been dead for years.
I'm sorry about your mom. But you would agree that when someone calls someone a son of a bitch, it's not necessarily a statement of fact. It's more a statement of opinion or a description of a person.
Sure.
This may sound stupid, but you've been a law enforcement officer for a long time, correct?
Yes.
You've been called many derogatory names, correct?
Over the years, yes.
You've been called a son of a bitch before, correct?
Not published, but yes.
Okay. You've been called other things even worse, correct?
I'm sure over the years I've been called many things.
It's fair to say that during those years, people probably said bad things about you and your family also.
You know, I honestly can't remember bad things being said to my family, but I can remember bad things being done to them.
So, are you testifying and claiming that because Mr. Foreman called you Gomer Pyle, you've been painted in a false light with the public?
I'm
taking
claiming
it one at a time, so I'm going to get to
the
it.
Gomer Pyle.
Yes.
I'm not claiming that, sir.
You're not claiming that being called a son of a bitch is a claim you're pursuing that Mr. Foreman's called you.
Correct, sir.
Being called Beetle Bailey, you're not claiming that is part of defamation proceeding on that, correct?
Correct.
And neither one of those three statements have painted you in a false light, correct?
Correct. Well, I mean, it depends. I mean, it paints you in a different light than what you are, but correct.
So you're solely being painted in a false light due to Mr. Walters saying he had sex with your wife.
Mr. Walters does have sex with his wife. Mr. Foreman doesn't.
Good catch on that.
Yeah.
So you're claiming that is the defamation statement is that he said he had sex with your wife.
Yes.
And that's painted you in a false light.
It's caused tremendous pain in my life.
I'll get to that. We have to go through false light first. So does it paint you in a false light?
Yes, that my wife is cheating on me with Mr. Foreman.
But we all know that's not true, correct?
I don't know.
Wait, you don't know if your wife's cheating on you or not?
You want to go there?
No, I just want to ask that question because you said we don't know.
I've been with that woman since middle school. I would hope she wouldn't. But you know what? Once somebody puts it out there for their fun and entertainment, it's out there. And it's a problem.
So it's something we cannot verify the truth of? Is it a thing that can be verified, true or false?
Ask your client.
Your Honor, I'm going to ask for a direct the witness to answer the question, yes or no, please.
That you don't like his answer doesn't mean he didn't answer.
He didn't answer the question. He told me to ask another person. That is not an answer to the question.
So ask him another question. That was his answer. You didn't like how it came out, but it was his answer. They can't make him say something else. You can ask him another question.
And so are you claiming that Mr. Foreman saying he had sex with your wife is a private fact about your life?
My family is a private part of my life.
About your wife?
Him having an affair with my wife would definitely be a private part of my life if that was occurring.
And that has affected your reputation?
Yes.
And so, am I right in concluding that the other final statement that you are claiming that Mr. Foreman said about you that painted you in a false light is that you're a thief?
Yes.
And that stems from all the posts that and all the exhibits that Mr. Klingler referenced earlier?
That's what he showed.
The ones that talk about the police officers in general?
Yes.
Did you order Lisa Phillips to disconnect the security camera?
I don't, and I haven't reviewed the body cam since that event. I know that the intent, if I can, for the camera system is, in speaking with Detective Newland, that they thought there was some type of operation of narcotics transfers there, so it would be obvious that if there's a surveillance system, that would be on it. That camera system was disconnected with my multi-tool by Sergeant Phillips. I will trust in the fact, because I have not reviewed it, that I said, hey, disconnect it. I don't know for sure that I did, but I know that she used the multi-tool to disconnect it, and it was placed in the central area in that room for evidence to be collected, because it was to be collected. Because obviously, if you thought something was going on in a residence, you collect the surveillance system, you go later and get another search warrant. I didn't find out until a couple days later that that was not actually collected.
It was left at the scene,
Yes.
but it was disconnected.
Yes.
And you were
To
standing
take his evidence.
to take as evidence,
Yes.
but it was not taken as evidence.
It was not.
So the only thing taken as evidence, significant evidence, was the cash.
There was a jar of marijuana that was found in like the ball cap room, some cash, and some vapes, as I remember.
Mr. Osborne targeted Sergeant Walters' claims of reputational damage, focusing on a satirical lyric implying a sexual affair with Sergeant Walters' wife. The defense argued that within the context of hip-hop satirical music, no reasonable person would take the claim as a literal statement of fact. In this civil suit, Sergeant Walters holds the burden of proof under the preponderance of the evidence standard, meaning he must prove his claims are more likely true than not. His eventual refusal to answer questions about the lyric only highlighted his lack of factual support. Mr. Osborne then shifted the focus to the video footage showing Deputy Lisa Phillips disabling Foreman's security cameras, allegedly under Sergeant Walters' direction. The defense argued that intentionally shutting down a resident's cameras exceeds the scope of a search warrant under the Fourth Amendment, amounting to government overreach and the spoliation of evidence. Under Ohio law, this police misconduct triggered the public interest privilege, which legally protects citizens who publish criticisms of public officials on matters of legitimate community concern. Because the seized camera equipment was never used in an actual criminal prosecution, the defense framed the entire raid as a failed state action that fully justified Mr. Foreman's public scrutiny over the missing money. On March 18, 2026, Joseph Foreman was cleared of all civil liability concerning the defamation and invasion of privacy claims. Avoiding the severe financial penalties typical of such lawsuits, the ruling fully preserved Mr. Foreman's legal right to feature his home surveillance footage in his creative projects. Our next case occurred on April 16, 2009. The state of Arizona leveled misdemeanor charges of resisting an order from a public official and obstructing a highway against Pastor Steven Anderson following a tense confrontation at an interior Border Patrol checkpoint. The incident occurred along Interstate 8 near Yuma, Arizona, when Mr. Anderson invoked his Fourth Amendment rights and refused to consent to a vehicle search or a secondary inspection. This defiance triggered a 90-minute standoff that only concluded when Department of Public Safety officers shattered his car windows, tased him, and pulled him from the automobile. The resulting criminal case went before Judge Elizabeth G. Underwood in the Yuma County Justice Court. During the trial on December 16, 2009, the state called Agent Ernesto Gomez, who had been present during the checkpoint clash. Once prosecutor Vincenzo Mazzeo concluded his direct examination, Mr. Anderson's defense attorney, John J. Schill, had the opportunity to cross-examine Agent Gomez.
To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen, and they say no, they're on their way?
No, sir.
Well, which is it? You just said If they say yes or no, they're on their way. But Dennis, you've said, I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, do you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go.
No, sir.
And now I'm confused again. I originally asked if you are unable to determine citizenship at the primary checkpoint, that you usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway?
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
Then what do you do with them?
I try to establish the citizenship there,
And suppose you can't.
and they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
Just ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. I'm there to reserve citizenship, sir. If somebody traveling through there saying some sort of checkpoint, they're U.S. citizens, they're free to go. If they're not U.S. citizens, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
What is your answer that you were not aware of any?
Yes, sir.
Thank you.
Mr. Schill exposed a major contradiction by confronting Agent Gomez with a recorded phone interview. In the audio, the agent admitted he was completely unaware of written checkpoint guidelines, directly flatly contradicting his live testimony. This discrepancy triggers Arizona Revised Statutes, Section 13-2702, which defines perjury as in knowingly making a false sworn statement about a material issue, a Class 4 felony offense. By forcing Agent Gomez to acknowledge the recording, the defense effectively showed that his courtroom assertions fit the statutory framework for perjury, proving he provided conflicting accounts while under oath on a material matter.
Mr. Anderson was sent to secondary inspection because of the dog alert. Is that correct?
It was a combination of both immigration and the canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not
Yes.
the dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore,
Correct.
before any immigration question was asked.
Correct.
And Agent Spoonamore gave you that signal because his dog alerted.
Correct.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
Mr. Schill challenged the legal basis for the secondary inspection by questioning whether the K-9's change in breathing truly qualified as a trained final response. Agent Gomez countered that handlers are explicitly trained to recognize these subtle physiological shifts as valid alerts, even in the absence of definitive behaviors like sitting or scratching. Under the Fourth Amendment, any vehicle search at an internal checkpoint going beyond basic immigration inquiries requires probable cause. While a certified dog's alert typically establishes this standard, federal jurisprudence, specifically United States versus Parada, 2009, differentiates between a loose behavioral alert and an official final response, requiring that an alert be objectively recognizable to meet the threshold of legal reasonableness. The defense argued that because the K-9 failed to execute its 3 trained final responses, the agent's interpretation was entirely subjective. Without a verifiable objective alert, the officers lacked the necessary probable cause to search the car or order the driver to exit.
When you directed Mr. Anderson to secondary, he was going to secondary to get his car searched, correct?
Correct.
Regardless of anything else, his car was going to be searched when he went to secondary. That was your intention, wasn't it?
Along with attempting to establish citizenship, sir.
Along with probably a whole lot of other things, but his car was going to get searched, wasn't it?
Yes, sir.
He's going to be made to get out of his car,
Yes, sir.
and the car was going to be searched.
Yes, sir.
And the dog decided that.
The team, the both K-9 and handler, decided that, sir.
Well, the dog is the one that alerted, correct?
Correct.
When you're at primary, you can decide to send people to secondary, correct?
Yes, sir.
Someone pulled up the primary with their passport open, showing that they were a citizen, your decision would probably be just to let them go, correct?
Yes, sir.
Have you ever sent someone to secondary who had absolute proof of citizenship out for you to see?
Yes, sir.
For what?
K-9 alert, sir.
Okay. Any other reason?
Yes, sir.
For what?
Their demeanor, the way they're acting, their story.
But if the K-9 alerts, if you're told the K-9 has alerted, it doesn't matter what you think. That car is going to secondary.
Yes, sir.
You can't overrule the dog.
No, sir.
You can't look at Agent Spoonamore and say, this guy's fine. Look at him. He's a white guy, short hair. He's got identification. Well, let me let him go. He's not Mexican. You can't say that, can you?
No, sir.
He's going to secondary.
Yes, sir.
Because the dog is a separate operation from what you're doing.
Yes, sir.
You're not a supervisor.
No, sir.
You can't overrule the dog.
No, sir.
Let me ask this differently. Assuming his authority then was the same as your authority now. So I'll ask you about your authority now. Fair enough?
Yes.
Okay. Your authority now as a K-9 officer, you can write citations for violations of what laws?
Sir, I'm still currently going through the training,
Uh-huh.
so I'm not done with all my training, so I'm not exactly sure on all of that.
Is it your understanding, and you can tell me if you don't know, that's a legitimate answer if you don't know, that K-9 officers can write citations, but that's a bad question. I'll withdraw that. So your understanding that Agent Spoonamore had the authority to arrest someone to take him to the Yuma County Jail and charge them with the state offense?
I am not exactly sure with the procedures with that, sir.
Or was it more write a citation like writing a ticket and letting them go?
Like I said, sir, I'm not done with all my training, so I do not know the process of that.
Fair enough.
Mr. Schill targeted Agent Gomez's legal authority to order Mr. Anderson from his vehicle, exposing a critical flaw in the agent's jurisdictional awareness. The defense argued Agent Gomez's admission of no crime suspected stripped the subsequent use of force of any legal backing under the Fourth Amendment. Consequently, Mr. Schill asserted that the command to exit the vehicle failed to qualify as a lawful order under Arizona Revised Statutes 28-622. Although this statute makes it a crime to disobey an officer's command, such orders must serve a legitimate law enforcement goal without infringing upon constitutional protections. The testimony further highlighted that the agents acted entirely on a subjective interpretation of a canine's breathing rather than a definitive, trained final response. While federal jurisprudence under United States v. Place establishes that a dog sniff is not inherently a search, the outcome must still yield an objective basis for probable cause to authorize deeper intrusion. Because the canine's reaction was unstandardized and no crime was initially suspected, Mr. Schill framed the officer's actions as an unreasonable seizure, transforming Mr. Anderson's defiance from criminal non-compliance into a legally sound defense of his civil rights. On August 13, 2010, a Yuma County jury completely rejected the prosecution's case, acquitting Pastor Stephen Anderson of both misdemeanor charges of obstructing a highway and resisting a lawful order. Our next case occurred on May 6, 2008. Michigan State Police Trooper Kaiser pulled over Jamie Jordan for a speeding violation. During the interaction, Trooper Kaiser reportedly spotted an open container of alcohol inside the car, which he claimed established the necessary probable cause to search both the vehicle and Jordan for further contraband. On March 1, 2011, an evidentiary hearing in Oakland County, Michigan occurred where Mr. Jordan faced misdemeanor charges of open intoxicants under Michigan Legislature 257.624 and possession of a forged or altered license under Michigan Legislature 257.257. The matter was brought before Judge Edward Sosnick in the Sixth Circuit Court. During the evidentiary hearing, the state called Trooper Kaiser to lay out its case. Following the conclusion of the direct examination by prosecutor Rick Polanco, defense attorney Neil Rockand took the podium to initiate his cross-examination.
All right. You're a state trooper?
That's correct.
And this Michigan State Police has policies, correct?
Yes, sir.
Okay. And those policies are called official orders, are they not?
Some of them are, yes, sir.
And they're assigned numbers, correct?
Some of them are, that's correct.
For example, there could be an order number 1 or order number 5, right?
That's correct.
All right. Order number 87. Have you heard that number before?
Yes, I've heard 87 before.
Have you heard order number 87 before?
Not by number, I couldn't reference it.
Would you agree with me that, let me see if this language, if you've heard this before in your experience, okay? Let me back up 1 second. The Michigan State Police has policies about preserving and collecting evidence, true?
Yes, sir.
The evidence collected has to be collected, cataloged, or indexed, correct?
Correct.
Evidence can be photographed, correct?
It can be.
Okay. And let me ask you, the Michigan State Police has a policy that says certain procedures shall be followed in order to ensure that a proper record is maintained of all property or evidence. Is that true?
Yes, sir.
Okay. Your Honor, I don't think there's any objection by the people who have already to the admission of Defendant's Exhibit A, which is Official Order Michigan State Police Policy Order Number 87. So I would move at this time to have Defendant's Exhibit A admitted. Unless, it's okay. If I misunderstood the stipulation, that's fine. If I did, then I'll question about it.
I'll stipulate that document. I don't know if it's an official. I don't have personal knowledge that's an official order, but I stipulate the admission of that document. Sure.
I'll receive it. Okay. And there's Defendant's Exhibit A. Now you testified that what policy number? We'll strike that. The Michigan State Police. You haven't produced, and tell me if I'm wrong, an actual written policy that says that in OWI or open intoxicant cases that you should dump out the contents of the bottle and or not actually catalog or preserve the bottle. Is that true?
You're asking if I've produced a
Yes.
document?
Yes.
I have not produced a document.
Okay. Is there such a document?
I am not sure, to be honest.
How did you get the order to process open intoxicants by pouring it out and giving the container back?
Judge, it's my contention that there is no such order in this. I understand.
I mean, obviously you don't see an order here, but how did you learn to do that? Who told you to do that?
Because order number 87 says that, and if I could just intercede, Judge, order number 87 says, if you look at the exhibit and you look at page 1 and page 2, it says the following procedures shall be followed in order to ensure that a proper record is maintained of all property. Evidence taken after 1/1/1999 shall be identified by attaching an exhibit label generated by the department's records management system. Not identified, and there's a sticker, obviously. And then evidence that received, transferred, removed, replaced, or disposed of the property segment shall be updated.
During cross-examination, Mr. Rockin targeted Trooper Kaiser's failure to abide by mandatory police protocols for handling physical evidence. He confronted the trooper with Michigan State Police Official Order 87, the agency's definitive manual governing evidence and property management and scene integrity. Mr. Rockin established that absolutely no policy within Order 87 authorizes an officer to discard the liquid contents of a confiscated bottle. The defense argued that destroying this material constituted the spoliation of evidence, representing a major breach of professional standards. By exposing this violation, the defense aimed to compromise the integrity of the entire investigation, suggesting the trooper either ignored or was completely ignorant of mandatory evidence preservation rules.
And so you take the license and you actually go back to your car, and I'm going to talk about your discussion with Mr. Jordan, but you go back to your car to run his name through Lean and or through the Secretary of State computer system, correct?
Yes, sir.
Now, as you're doing this, understand that all you possess in your hand is this driver's license, right?
Yes, sir.
You had asked him some questions about his driving record, right?
Yes, sir.
He said he had a couple of tickets in the past. True?
Yes.
You didn't ask him what specific types of tickets they were. Is that true?
That is correct.
You didn't ask him where those tickets were, like in what court, for example. Is that true?
Correct.
And you didn't ask him how those tickets were disposed of, in other words, whether they resulted in conviction, dismissal, or resulted in some non-abstractable offense, correct?
That is correct.
Let's talk about how tickets can be resolved. In your experience, in your 15 years, you know that you can issue a civil infraction ticket for an individual, right?
Yes, sir.
The civil infraction ticket itself person would have to go to court to typically contest that ticket, is that right?
Typically.
Okay, well, let's talk about the cases where they don't. It could be, for example, a waivable offense. A waivable offense is what? Like defective equipment, or could be no registration, or no proof of insurance, something like that, correct?
No proof of insurance is no longer waivable.
Okay.
But
Tell the judge what a waivable ticket is.
it's a ticket in which the defendant can take to a police authority to sign off on the ticket, mail that ticket into the court, and it gets waived or canceled.
Okay. In other words, Mr. Jordan told you that he had a ticket, right, in his past?
Yes, he did.
You did not know at that time whether it was a waivable ticket or whether it was a non-waivable ticket for which he'd have to go to court. True?
That's correct.
And can we agree that you didn't investigate that?
At that time, no, I did not.
Can we agree that you assumed the worst when you heard the word ticket, that you heard or thought that it was like speeding or something, that you assumed the worst at that point?
I don't know that I characterize it as worst, but
you assumed that it was, you assumed something. You jumped to a conclusion about what the word ticket meant, right?
I was asking him about his record.
I understand.
So if
It's pretty clear in your mind that what you weren't referring, that you didn't leave room for the option at that point that he was saying ticket could have been a waivable ticket or something of that. You didn't think that at that time. You weren't thinking that way, were you?
If you'll allow me to answer the first part of your question.
Yeah, I just want to know whether you...
For your next statement as you're doing counsel.
Go ahead.
All right. When I asked him about his record, I'm assuming that meant a ticket on record, meaning some type of conviction, not a ticket that was disposed of, or it wouldn't be on his record. So I asked him about his record. He said he had a couple of tickets.
You know that when I interview clients and I ask them if they have anything on their record, they always say that too, that they have had a couple of traffic tickets. Sometimes those don't show up on records. You'd agree with that, right?
Sometimes, yes.
A truthful answer, the most honest answer a person could give you about whether or not they had anything on their record, if they didn't know if it was there or not, would be to tell you they had a couple tickets in their past. Is that true? That'd be the most truthful answer, wouldn't it?
I don't know about it being the most truthful, sir. That would be speculative.
Okay.
Mr. Rockin used official Secretary of State records to impeach Trooper Kaiser, revealing a major contradiction in his justification for the arrest. Although Trooper Kaiser testified that the defendant's license status mandated taking him into custody, the state records proved the infraction was far less severe than portrayed. This conflict directly invoked Michigan Rule of Evidence 613, which allows a witness's credibility to be challenged when their claims clash with established facts. Additionally, Mr. Rockin targeted the trooper's highly irregular exercise of police discretion. He established that the underlying offense was a minor civil infraction that typically results in a waivable ticket, allowing a driver to clear the citation by showing proof of compliance. Instead of following standard protocol, Trooper Kaiser bypassed it entirely to execute a full custodial arrest and physical search. The defense framed this deviation from departmental policy as evidence of an ulterior motive, suggesting the arrest was a strategic maneuver to circumvent Fourth Amendment protections rather than a legitimate action for public safety.
All right. You told the judge that an important factor in consideration was that the license had been issued, best of your recollection, within 6 months of the incident date. Do you remember that?
My recollection was that that's
I understand.
correct. And I misspoke.
Right. The license actually had been issued December 2nd, 2004. Is that right?
Yes, sir.
Okay. And even though it was in its first cycle of the license, you would agree that the probationary period for that license, when you stopped Mr. Jordan on May 6th of 2008, had ended. Isn't that true? Probationary period does not last 4 years, does it?
No, sir, but the license had not been renewed.
I understand that. I'm saying, though, that it was not in the, quote, probationary period. Would you agree with that?
Let me refresh myself. I don't believe you'll have the lien work in here, counsel. I may have to obtain that from the prosecutor, reference the probationary status.
It really isn't that major of a point, Judge. It's just, if he wants to dig for it and give it to us later, it's fine. My point was that the license was 4 years old as opposed to...
It had not been renewed.
I understand.
It was an original license. I did misspeak on the particular time frame that it had been in existence.
Okay. And if you could share with me, Trooper, this card. You said you searched through his pockets after he was placed under arrest. Is that right?
I did.
And you searched through his wallet, I believe. Is that right?
Yes, sir.
And you told the judge that you found some cards or credit cards in the name of Mark Johnson. Is that right?
Correct.
And you found one card that had the name Jamie Jordan on it, right?
That's correct.
And could you show us in the discovery where that card that had the name Jamie Jordan is? Did you take a photograph of it or a copy of it or preserve it in evidence?
No, sir.
Did you save that piece of evidence at all?
No, sir, I didn't feel it was evidence.
Mr. Rockin scrutinized Trooper Kaiser's handling of the physical cards seized from Mr. Jordan's pocket. While the officer was incredibly thorough in documenting multiple cards under the name Mark Johnson to build an identity fraud theory, he admitted to also uncovering a card displaying the defendant's legitimate name, Jamie Jordan. This omission allowed the defense to expose severe investigative bias and challenge the overall integrity of the state's case. By Trooper Kaiser admitting he didn't feel the true name card qualified as evidence, Mr. Rockin successfully demonstrated that law enforcement engaged in selective preservation, deliberately keeping incriminating items while actively discarding exculpatory facts that favored the defense.
Yes, sir.
In other words, the objective information that you got from your lien run was that this man with this license and this name was allowed to drive in the state of Michigan on this date, correct?
That's what a fraudulent obtained license
Hold on,
is.
I didn't ask you that. I just want you to answer my question. I know what you want to tell Mr. Polanco. Just answer mine, okay? The actual Secretary of State lien run that you showed was that he was lawfully allowed to drive, correct?
Under that identity, yes.
Okay. So the entire investigation arrest sequence lasted approximately 4 to 5 minutes, true?
Ballpark.
And it's at that point that Mr. Jordan was removed from the car. You began your arrest or detention procedure, correct?
Correct?
Would you agree with me that at that point, Mr. Jordan was not free to leave, that he was being detained by you?
That's why he was in handcuffs.
Okay. What you just said about how long it took and what you did with Mr. Jordan, that's not entirely true, is it, Trooper Kaiser?
I don't understand your question.
Well, when you returned to Mr. Jordan's car from having done your lean run, you actually you swore at him, didn't you?
No, sir.
Didn't you say to him, who the F are you?
No, sir.
Didn't you press him about what he was doing and you wanted to get to the bottom of it and you were going to? Didn't you do that?
Judge, if I can, I think this is outside the scope of my redirect, and this is basically a whole line across.
You know what?
There's...
It may be true. I have discretion. I want to let's get all the facts out. This is really the whole key to this situation. Okay.
Isn't it a fact that you actually continued to press Mr. Jordan about details and whatnot for approximately 45 minutes from the time that you stopped him until you actually made the decision to arrest him and to call for a tow? Isn't that true?
Absolutely not.
Okay. You called for a tow, would you not agree, and I mean a tow like your decision to impound his car, you did do that, didn't you?
Yes, sir.
And you made the decision there was no one there to take over his vehicle once you arrested him, correct?
I would have stood by for the tow truck, but Trooper Millhouse arrived.
Okay. Have you looked through the report, by the way, to answer the question I asked you before about Trooper Millhouse?
No, you've been kind of long-winded, Counsel. I haven't had an opportunity. Give me a moment.
Sure. You can berate me, and it's okay by me. No problem.
No one's ever said that about you.
No, they haven't. Well, it won't be the first time. I also have. Won't be the last. Won't be the last time that I've. This won't be the last time that I've also cross-examined a police officer who has wit and charm.
That's a compliment, Trooper.
Thank you.
Not for me, from him. Don't thank him.
Would you, Mr. Polanco was looking for the document where you referenced Trooper Millhouse as your backup officer. I anticipate a forthcoming concession from him.
I already conceded.
That it doesn't, it's not there, is
I
it?
misspoke about a different trooper, sorry. I apologize.
You completely omitted her from your report, isn't that true?
Structurally, yes, sir.
Okay. I have no clue what that means structurally. Do you mean that you didn't mention that the Burnett and Millhouse actually played an official role in this case in some capacity or other? Is that what you mean by that?
She played no part in the arrest sequence and criminal proceeding of this case.
I just want to know whether or not, you said structurally, do you mean that in the entire body of this police report that you did not reference Trooper Millhouse having played any role?
She should be listed on the vehicle form, but I'm not seeing it in the stack of documents you gave me.
Is there some document? I want to be clear that I've given you a packet that contains an investigation that spanned what looks like a couple of years.
Yes, sir. I don't see the document in there.
Trooper Millhouse, you didn't even reference that you even had a backup officer that day, isn't that true?
I'm sure I mentioned it in our prior court proceedings, but I don't see it in our report, sir.
I know, because I questioned you about it. I'm talking about, you know that I'm talking about what you wrote in your report, not what you're answering to my questions. I just want to know, would you concur that either that or Mr. Polanco, would you concur that she's omitted entirely from your report?
As I've seen it, I don't see her memorialized in the report.
Okay. And if you arrested Mr. Jordan within 4 minutes or 5 minutes of your having stopped him, which is what you testified to, you didn't call for backup or for a tow operator to come do anything with his car until what looks like about 10:30 or so. Do you dispute that?
No, I wouldn't dispute that.
So you actually had this man alone at the scene with just you. You're saying he was under arrest for about 45 minutes or so from the time. Is that right?
Including the time I stopped him, our conversation, computer checks, searching the vehicle prior to impounding it, and requesting a hook. That was probably about 40 minutes.
Well, the policy, actually, the state police policy about searching the vehicle pursuant to impound is that you actually have to have the impound operator actually sign off on the contents of the vehicle. Isn't that true?
Yes, sir.
Okay. Well, you just said you searched the vehicle before you even called for impound.
That's right.
So you did the search without even having the person who's going to take the car actually even look through the contents to verify that what you say you found is what you found. True? Is that true?
Please rephrase that.
You say that during the 45 minutes or so that you searched through this car, that you did it without the impound or tow operator even being there.
That's correct.
So you couldn't have followed the state police policy which says that you're supposed to have the tow operator actually observe what it is that you found during the search of the car so that the accused belongings can be properly chronicled. Correct?
That is incorrect.
Okay, so you have Mr. Jordan, you said, and during that 40 minutes or so, from the time that he was arrested until the time that you called for this tow company to come, you're saying you didn't ask him any questions at all. You didn't berate him. You didn't press him about who he was.
I was busy searching the car. Upon arrest, he was inquiring to me what this was all about, and I told him I did not believe the identity he provided was true, and I placed him in my patrol car.
Where is that in your police report? Where is that colloquy in your report, Trooper? Where's any of that? Go ahead. You got the whole report there. Look through it. Find the spot where you said that he questioned you about that and you engaged in that colloquy.
Sir, it wasn't a question to him, nor a response to one of my questions.
I understand that, but you didn't. This is a statement by an accused. You're claiming he made a statement to you at the scene. Where is that statement referenced in your report? Would you agree that it's not?
Absolutely, it is not.
Defiantly that it's not. You know it's not.
Correct.
So you have an accused that's asking you questions about reasons why he's being stopped, and you just omit that entirely.
You can ask it 10 different times, counsel. The answer is going to be no.
Now, you testified that as you were in this discussion with Mr. Jordan, where you had going through the belongings in his wallet and whatnot, and you hold up this Sam's Club card, that you say that took place in your patrol car.
Correct.
You know, I thought we're limiting this.
We are.
To the basis for the arrest.
I did too, Your Honor.
We are, Judge.
He annoys me sometimes.
He must get paid by the word, Your Honor.
You know what's interesting is I thought the same thing about you, Trooper Kaiser. I thought you got paid by the word. Would you just, and I'm just going to hand you what we've previously marked as Defendant's Exhibit E, just to corroborate what I said about the tow records and when the tow truck was called. Have you seen those before?
No, sir.
Is that the tow company that you called?
It appears to be.
That the tow company that responded?
I have no independent knowledge of their records or process keeping, so it's paperwork with their name on it. It's all I can tell you.
Mr. Rockand attacked the validity of the arrest by pointing to the glaring discrepancies between what Trooper Kaiser stated on the witness stand and what was left out of his formal incident report. First, the defense revealed that the trooper completely wiped any mention of a second responding Michigan State police officer from his written narrative. By deploying the legal strategy of impeachment by omission, Mr. Rockand argued this lack of transparency proved the report was an intentionally curated story built to protect the trooper's version of events from being challenged by another witness. Mr. Rockand also confronted the precise moment of arrest and the arrival of the impound vehicle. Because standardized reporting mandates these exact time markers to verify the constitutionality of a roadside detention, Mr. Rockand asserted reported that the documentation violated the trustworthiness requirement of Michigan Rule of Evidence 803-8. Ultimately, the defense framed the entire encounter as a targeted setup, arguing the trooper had predetermined his intention to jail the driver well before any actual infraction was discovered. This rendered the official police report a mere retrospective formality designed to backfill the facts, forcing the trooper to rely on a reconstructed memory tailored for a conviction rather than the objective truth of the encounter. On the same day, the court dismissed all the charges against Mr. Jordan. These cases collectively illustrate that the integrity of the judicial system hinges a lot on the credibility, accuracy, and transparency of law enforcement. When police investigations falter, the courtroom transforms into a crucial testing ground where constitutional protections must actively shield citizens from state overreach and curated narratives. Challenging the integrity of an investigation is not merely a defensive tact, it is a vital mechanism for ensuring systemic accountability. A police report or a state-proffered timeline is not an unassailable truth. It is a narrative subject to strict constitutional scrutiny. True justice cannot survive on systemic shortcuts, selective evidence preservation, or institutional protectionism. Preserving civil liberties requires an uncompromising commitment to transparency from the initial street encounter to the final verdict under oath. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.